So let's do a couple of questions on this topic. First, a partnership may be dissolved A. on death of partner, B. on completion of work or venture, C. on expiry of term, D. all of the above. This is very simple. All these are valid grounds for dissolution. So the answer should be all of the above. Okay. Next, voluntary dissolution is dissolution by adjudication of all the partners as insolvent, dissolution as a result of an agreement between the partners, dissolution by business of the firm becoming unlawful. D. all of these. Voluntary dissolution means dissolution by mutual agreement. Okay. So, which of these comes under mutual agreement? The point that comes is second, dissolution as a result of agreement between the partners. Okay. Next, which of the following are grounds for compulsory dissolution of the firm by court? When does the court compulsorily dissolve the firm? By court order. Okay. A. insanity of partner, B. misconduct of partner, C. perpetual losses in business, D. all of these. Again, this is very simple. In all these cases, the court will order for dissolution. Okay. Next, application for dissolution of a firm on the ground of permanent incapacity of a partner can be made by A. any partner, B. any partner other than who is permanently incapacitated, D. police officer, D. CBI. Who can make the application for dissolution? It's either that person or any partner. Anyone may apply. Okay. Next, courts can order dissolution of a firm on the grounds other than A. misconduct, B. superannuation of a partner, C. incapacity of a partner, D. continued losses. See, in case of continued losses, the court may order dissolution. Incapacity, the court may order dissolution. For misconduct also, the court may order dissolution. But for superannuation of the partner, the court cannot order dissolution, because superannuation means reaching the age of retirement. What is superannuation? Reaching the age of retirement. Now, this is not court's business, because this is valid only for employees. A partner is not the employee of the firm, he is the partner, he is the owner. So this does not apply to the owners. The court cannot order dissolution just because one of the partners has reached the age of retirement. You see many partnerships where persons of the age 65, 70, 72, even 80 still continue. So firm cannot be dissolved on this ground. Okay. Next, a partnership firm is compulsorily dissolved where A. all partners have become insolvent, B. firm's business has become unlawful, C. the fixed term has expired, D. in case all partners have become insolvent and firm's business has become unlawful. In which case the firm will be compulsorily dissolved. The firm cannot be compulsorily dissolved if the fixed term has expired. The firm can be compulsorily dissolved if all the partners become insolvent, the firm can be compulsorily dissolved if firm's business has become insolvent. But we have the D option which covers A and B both. So we go with D option. Okay. Next. In the absence of any contract to the contrary, insolvency of a partner results in A. Dissolution of partnership, but not of the firm. B. Dissolution of the firm as well as partnership. C. Neither dissolution of firm nor dissolution of partnership. D. None of the above. The answer is dissolution of the firm as well as the partnership. Both get dissolved if one of the partners is declared insolvent. A partnership will not be compulsory dissolved if A. One of the partners of the firm becomes insolvent, B. The business of the firm becomes illegal, C. Only one of the several businesses which can be separated from the other business of the firm become illegal, D. Different business run by the firm cannot be separated. I know that partnership will be compulsorily dissolved if one of the partners become insolvent. Again, if one of the partners become insolvent, the firm will be dissolved. Even if the business of the firm has become illegal, it will be dissolved. However, if the firm is doing many businesses, let's say if it is in the business of selling shoes, it is in the business of selling mobiles, cell phones, it is also in the business of selling FMCG goods, that is goods like soaps, detergents, perfumes, deo sprays, stuff like that. So now if let's say the cell phone business has turned illegal and it's a separate business, so will the firm get dissolved or that business needs to be shut down? This is the third option, wherein the firm has many businesses and one of the business which can be separated has become illegal. The D option is contrary to this. There are many businesses that the firm runs, but these business can't be separated from each other. It's like it manufactures soaps and then it sells soaps as well. So when it manufactures, there are two businesses. It manufactures also and it sells also. So when it manufactures, it sells to outsiders as well as uses it for its own consumption and then makes detergents from it. So now these are two businesses which cannot be separated. You first manufacture a soap. Some soaps you sell directly to the clients, others you use for making detergents. So now these two are very linked with each other and cannot be separated. So in which of the cases the firm will not be compulsorily dissolved? It will be this. Because the business which has become illegal, it can be shut and the remaining firm becomes legal and it can continue. But in this case, it is not separable, it is inseparable. So the whole firms become illegal and it has to be shut down. Okay. So this is the answer. Next, when all the partners except one become insolvent, the firm is A. compulsorily dissolved, B. not compulsorily dissolved, C. reconstituted, D. renewed. When all the partners except one, then the firm will be compulsorily dissolved. We have already covered this. It will be compulsorily dissolved. Next, on the ground dash, one or more partners of a firm individually or together apply to the court for dissolution of the firm. A. Partner being of unsound mind, B. Misconduct of partner. C. Persistent losses in the firm's business. D. All of the above. In which of these cases one or more partners of the firm individually or together can apply to the court for dissolution? In this case, they can apply. This case also they can apply. In this case also they can apply. That means the answer is all of the above. When a partner of a firm is adjudicated as an insolvent, he ceases to be a partner as on the date of the order of adjudication, on the date of dissolution, on the date of information of insolvency, the as decided by Indian partnership firm. So if a partner becomes insolvent, he ceases to be a partner as on the date of adjudication order, when the order of adjudication comes, which declares him as insolvent. Adjudication means declaration. Okay.